federal bankruptcy judge just told a major bank, "You cannot take your own car back." The bank had done everything right. The motion was filed. The collateral was destroyed and uninsured. The debtor couldn't pay. This should have been the most straightforward repossession hearing on the docket that day. And yet the judge looked at the motion, looked at the facts, and said no. No explanation. No clear reasoning. Just denied. What happened next would leave one man's car legally frozen in a driveway in Illinois for over 2 years, and counting. Here is the full story. To understand how a perfectly ordinary car loan became a federal legal standoff, we need to go back to 2020, when a young man in Illinois financed what he considered his dream car, a Dodge Challenger Hellcat. For those unfamiliar, the Hellcat is a high-performance American muscle car producing over 700 horsepower from the factory. It is not a modest vehicle. But the financing was structured, the payments were manageable, and for a time, life was moving forward. Then, as it so often does in these cases, a single catastrophic event set an entire chain reaction in motion. In late 2023, his mother was diagnosed with cancer. Medical bills in the United States are notoriously relentless, and this family was no exception. Within months, he had accumulated approximately $15,000 in credit card debt simply trying to keep pace with her care. He made a decision that over 400,000 Americans make every single year when the weight of debt becomes unsustainable. He filed for Chapter 7 bankruptcy. It was not a decision made lightly. It was a decision made in a hospital waiting room. Chapter 7 bankruptcy, that is the liquidation form where a trustee may sell non-exempt assets to satisfy creditors, and remaining eligible debt is then discharged, legally wiped away. It is a fresh start, but the moment that bankruptcy petition is filed, something called the automatic stay goes into effect. Immediately. Automatically. This is a federal court injunction that halts virtually all creditor collection activity against the debtor, including, critically, the repossession of a vehicle. Every collection clock in the country stopped for this man the moment that petition was stamped. And then came the accident, early 2024. He was driving the Hellcat in rain, and here is where his own transparency is important. The car was fitted with slick tires, track tires, tires that are not street legal and are specifically designed for dry racing surfaces. On a wet Illinois road, the rear end broke loose and he hit a guardrail. The car was totaled. Completely undrivable. And because the cause of the accident involved illegal tires and driver fault, his insurance company denied a full payout. The car went from an asset to a problem instantly. Now consider the bank's position, because fairness demands we do. Their collateral, the physical asset securing a loan worth thousands of dollars, is now a destroyed vehicle sitting in a private driveway. It cannot be driven. It cannot be resold at auction. It is depreciating to near zero with every passing week. The debtor is in active bankruptcy proceedings and has stopped making payments. From the lender's perspective, the only rational move is to file a motion in bankruptcy court asking the judge for permission to repossess. That motion is called a motion for relief from the automatic stay. Bankruptcy attorneys who handle these motions routinely will tell you they are granted at an extremely high rate. To win relief from the automatic stay on a secured vehicle, a creditor must show one of two things: either that the debtor has no equity in the vehicle and it is not necessary for the debtor's reorganization, or that the creditor is not adequately protected. In a Chapter 7 case involving a totaled, uninsured, worthless car, where the debtor has ceased payments, both boxes are checked. This motion should have been granted without a second look. The judge said no, and here is the most maddening detail of this entire case. Nobody can fully explain why. His own bankruptcy attorney, the professional he hired specifically to navigate this system, had told him beforehand that the bank would be permitted to repossess at any time. Then the court issued its denial, and no clear explanation was provided. Bankruptcy judges have extraordinarily broad discretion. They sometimes consider procedural defects in how motions are filed, timing issues, or factors that never appear in the public record. Without the actual court transcript, this denial remains, legally speaking, a mystery. What would you have done in that courtroom? Let's pull back and look at the legal framework governing this moment, because understanding it changes everything. Under 11 U.S.C. Section 362 of the United States Bankruptcy Code, the automatic stay is one of the most powerful protections in federal law. It is immediate and comprehensive. Creditors who violate it, who attempt to collect or repossess without court permission, can be held in contempt and face sanctions. Banks know this. That is precisely why they file the motion, instead of simply dispatching a tow truck. Some legal observers who have reviewed similar cases suggest a few possible explanations for a denial in this scenario. The motion may have had procedural defects, improper service, missing exhibits, or filing errors. The bank's documentation of the loan status during active bankruptcy proceedings may have been incomplete. Or, and this is the counterintuitive angle, the court may have had reasons related to the debtor's mother, the medical hardship, or equitable considerations that weighed against the bank in that specific moment. Courts are human institutions. Equitable discretion is real. Here is the counterintuitive angle that almost everyone in this situation misses. The bank being denied relief was not a victory for anyone. The bank could not repossess. They could not resell. Their collateral sat rotting in a driveway while the loan accrued no productive value. The debtor had no functional vehicle. The landlord had an eyesore. The insurance companies had closed their files. Every party involved was frozen in a legal state that benefited no one. The court's denial did not solve a problem. It created a standoff. Fast forward to September 2025, 18 months after the accident, nearly 2 years after the bankruptcy filing. A letter arrives from the bank. They have elected to forgive his remaining loan balance. Debt forgiven. Done. Then, in November 2025, a check arrives. His GAP insurance, Guaranteed Asset Protection Insurance, which covers the gap between what you owe on a vehicle and what your primary insurer pays after a total loss, paid out the remaining balance on the now forgiven loan. On paper, every financial obligation was resolved. The nightmare appeared to be over. It was not. Owing nothing on a car is not the same as owning the car. This is a legal distinction that trips up thousands of Americans every year. In Illinois, as in every state, a motor vehicle is legally transferred through title, a state-issued document. And as long as a lender has a financial interest in that vehicle, they hold a lien on the title. That lien must be formally released before the title can be cleared. Without a lien release, that car cannot be sold, junked, donated, or legally transferred. It is his problem, and only his in perpetuity. He called the bank's bankruptcy department and formally requested a lien release, standard procedure. They confirmed the request and told him to expect the paperwork in 10 business days. He waited. Nothing arrived. He called again. The representative apologized. The first request had not been properly submitted internally. It was being resubmitted. Another 10 business days. He waited again. Again, nothing. On the third call, he was told the process was actually more complicated than originally communicated, and he should expect the release by the second week of January. January arrived. The mailbox stayed empty. This is the institutional failure at the center of this case's final chapter. Debt forgiveness and lien release are handled by entirely separate departments within most large banking institutions. In a case involving a bankruptcy, which adds a layer of legal compliance, court record keeping, and potential trustee involvement, the lien release process may require documentation from the bankruptcy court itself confirming the case status before the bank's legal team will authorize the release. When you call customer service, you are not speaking to the person who can actually solve this problem. What are his actual legal options, and what should he do right now? First and immediately, send a formal written demand letter to the bank via certified mail with return receipt. State clearly that the debt has been forgiven, the GAP insurance has paid, and that he demands a lien release within 30 days or will pursue legal remedies. Document every prior call dates, representative names, reference numbers. This creates a paper trail that courts take seriously. Phone calls disappear. Certified letters do not. What would you do first, the letter, or go straight to court? If the certified demand goes unanswered, his next step is the bankruptcy court itself. If his case is still technically open, which it may be, depending on whether the judge ever formally closed it after that unusual denial, he can file a motion to compel the bank to release the lien. Federal bankruptcy judges do not enjoy watching their prior orders ignored, and a documented pattern of administrative failures by a creditor is exactly the kind of record that produces court-ordered compliance. The bank has already lost once in this courtroom. They may not want to go back. But let us not lose sight of the human dimension of this case. He is a renter. His lease expires in 8 months. When he moves, he cannot legally take that vehicle with him because he cannot transfer a car without a clear title. He cannot sell it to cover moving costs. He cannot donate it to a charity. He cannot junk it for scrap and put the money toward a security deposit. Every legal path forward requires that single document. 8 months sounds like a long time. In legal proceedings, it is not. And then there is the landlord. He describes him as, quote, a super nice guy, a man who has extended patience and kindness well beyond what most landlords would, but consider his position fairly. A wrecked vehicle has occupied his property since late 2023. That is over 2 years. Depending on the neighborhood, this may affect property values, create homeowner association concerns, or simply signal, unfairly, but visibly, that the property is not being maintained. The tenant's explanation is legally accurate, but a legally accurate explanation does not make the car disappear. There is also a tax dimension worth flagging. When a bank forgives debt, the IRS can treat that forgiven amount as ordinary taxable income and will sometimes issue a 1099-C cancellation of debt form. This surprises people every year. However, under IRS publication 4681, debt that is discharged in a formal bankruptcy proceeding is specifically excluded from gross income. His bankruptcy filing may actually protect him from a tax liability on the forgiven balance, but this is not a certainty. He should confirm his specific situation with a qualified tax professional before filing this year's return. The broader lesson of this case is one that attorneys who practice bankruptcy law will recognize immediately. The end of a financial obligation on paper almost never means the end of the administrative process. Bankruptcy proceedings, auto loan servicing, insurance claims, and state DMV title systems are 4 separate bureaucracies operating on 4 separate timelines with 4 separate documentation requirements. When all 4 collide in a single situation, as they did here, the delays do not add, they multiply. The system was not designed to be cruel. It was simply never designed to talk to itself. As of the time this story was shared, the car remains in the driveway. The lease clock is ticking, and a man who navigated his mother's cancer diagnosis, $15,000 in medical debt, a federal bankruptcy filing, a totaled high-performance vehicle, an unusual court denial, and 18 months of institutional silence, is being held hostage by a Lien release that should take a bank paralegal approximately 20 minutes to generate. If his formal written demands go unanswered, his path leads directly back to the courtroom. And this time, he will not be asking the judge for a favor. He will be asking for a court order. If you are navigating a bankruptcy, a Lien release dispute, or a title issue of your own, the first step is always documentation. Every call logged. Every letter sent certified. Every date recorded. We have linked a breakdown of Illinois vehicle title law and your rights when a creditor fails to release a lien in the description below, including the formal demand letter process and when to escalate to the bankruptcy court. And if you have ever been caught in a legal limbo like this one, trapped between a court ruling and a bureaucracy that simply will not move, we want to hear your story in the comments. If this case taught you something today, subscribe to Courtroom Chronicles. Real cases. Real law. The moments that change everything.